Thank you, Tom, for that wonderful introduction. It's a pleasure to be here. It's such a great honor to be giving the Leonard Liggio Lecture. I first met Leonard when I was a first-year law student, in a first semester of first-year law student, when in 1974, when I came down to New York to hear him give a lecture at Fordham, and in the audience was Murray Rothbard. So that day, the day I met Leonard, was the day I met Murray. And then just one thing led to another after that. You can imagine those two guys together. And Leonard has done so much for my career. I'm sure I wouldn't be here today if it weren't for him, but I also know him well enough to know that he would not want me talking about him so much. And I was also greatly pleased to be here for the first Liggio lecture when Leonard himself was here and could attend this lecture. But I will now move off of Leonard, which he would want me to do if he were here, and get on to my talk, because if Leonard was all about the ideas and not at all about personality. And the talk that I'm going to give you is a preview of my next book, Our Republican Constitution, which will be published by HarperCollins in April of next year. And it's going to be my first trade book that's been written for a popular audience. So let me just start here. In 1789, James Madison had a problem. After living for 10 years under the Articles of Confederation, Madison had worked tirelessly behind the scenes to bring about a convention to devise a new constitution. In September of 1786, he participated in a preliminary convention in Annapolis, Maryland. By 1787, he had secured enough support of such key players as George Washington and Ben Franklin to convene a constitutional convention in Philadelphia. But now, the pressure was on the 36-year-old Madison. Before journeying to Philadelphia, he crammed for the gathering like a student for his exams, from a chest of books that he had been given by his friend and mentor, Thomas Jefferson. For the cerebral Madison had a truly fundamental problem to solve. Like many others, he had concluded that the American regime governed by the Articles of Confederation was grossly inadequate and contrary to what the Virginia Declaration of Rights had called the common benefit, protection, and security of the people. But why was this happening? Why had the republicanism of the founding generation failed them so? For the previous 13 years, the people of the United States had been governed by 13 separate entities. State governments under the Articles of Confederation were thought to be Republican. The founders had thrown off rule by an aristocratic few in favor of rule by a democratic many. If under aristocracy, the many are screwed by the few, the Democratic or Republican alternative was premised on the belief that the people wouldn't screw themselves. This is a technical legal phraseology. This is probably some kind of a residual effect of my having been a Cook County State's attorney before I became a law professor. But anyway, the theory was the people wouldn't screw themselves, but this Republican theory had unexpectedly proven to be false. State legislators began enacting debtor relief laws that both undermined the rights of creditors and impaired economic prosperity, which requires a credit market that can safely rely on the obligations of private contracts to collect from debtors. States also erected a debilitating assortment of trade barriers to protect their own businesses from competing firms in neighboring states. There was, as a result of all this, a national economic downturn. So Republican government, as it was then conceived, was clearly not working for the common benefit, protection, and security of the people. But why not? To answer this question, in April of 1787, largely for his own benefit, Madison composed an essay called The Vices of the Political System of the United States. In Vices, Madison identified the source of the problem in what he called the injustice of the laws of the states. The injustice of the laws of the states were his words. The causes of this evil, he referred to it as this evil, he contended, could be traced to, quote, the representative bodies in the states and ultimately to the people themselves. This, he wrote, called, quote, into question the fundamental principle of Republican government that the majority who rule in such governments are the safest guardians of both the public good and private rights. That was the central premise, he said, was called into question. Madison concluded that we must be far more realistic about popular majorities. All civilized societies, he explains, quote, are divided into different interests and factions, as they may happen to be creditors or debtors, rich or poor, husbandmen, merchants, or manufacturers, members of different religious sects, followers of different political leaders, inhabitants of different districts, owners of different kinds of property, etc. In a democracy, the debtors outnumber the creditors, and the poor outnumber the rich. The larger group can simply outvote the smaller. The majority, however composed, Madison continued, quote, ultimately give the law. Whenever, therefore, an apparent interest or common passion unites a majority, what is to restrain them from unjust violations of the rights and interests of the minority or of individuals? To illustrate the problem, Madison posed the following thought experiment, quote, place 3 individuals in a situation where the interest of each depends on the voice of the others, and give to 2 of them an interest opposed to the rights of the third. Will the latter be secure? The prudence of every man, he said, would shun the danger. Likewise, quote, will 2,000 in a like situation be less likely to encroach the rights of the 1,000? In short, under the democratic vision of republicanism, there is nothing stopping a majority of the polity from engaging in self-dealing at the expense of the minority. Madison concluded that what was needed was nothing less than a new Republican form of government that would address the weaknesses of democratic state governments while preserving popular sovereignty. As Madison put it, quote, to secure the public good and private rights against the danger of such a faction, and at the same time to preserve the spirit and form of popular government, is the great object in which our inquiries are directed. Now, Madison was not alone in locating the ills facing the nation in the majoritarian democracy of the states. At the Philadelphia Convention, Edmund Randolph, who became our first Attorney General of the United States under George Washington, observed that, quote, the general object was to provide a cure for the evils under which the U.S. labored, and that in tracing these evils to their origin, every man found it in the turbulence and follies of democracy, unquote. Elbridge Gerry from Massachusetts stated, the evils we experience flow from an excess of democracy, unquote. Roger Sherman of Connecticut contended that the people, quote, immediately should have as little to do as may be about the government. Gouverneur Morris from Pennsylvania noted that, quote, every man of observation has seen in the democratic branches of state legislatures precipitation, in Congress changeableness, and in every department excesses against personal liberty, private property, and personal safety, unquote. Now, even those who remain more amenable to democracy, like George Mason of Virginia, admitted that, quote, we have been too democratic in forming state governments. At the conclusion of the convention, anxious citizens gathered around Independence Hall to learn what had been produced behind closed doors. It is said that Benjamin Franklin left the building. As he left the building, a woman in the crowd asked him, well, doctor, what have we got? A republic or a monarchy? Franklin is said to have responded, a republic, if you can keep it. While the new form of government devised in Philadelphia was not a monarchy, neither was it democratic. Yet Franklin still called it a republic. This was because the meaning of that term had just been changed by the men in the building from which Franklin was leaving. A Republican Constitution was no longer a democratic one, if it ever had been. In my book, Our Republican Constitution, I contend that these two fundamentally divergent views of the Constitution divide us even today. I call these divergent views the Democratic Constitution and the Republican Constitution, but I don't intend these labels to be partisan. There are political conservatives who hew to some aspects of the Democratic Constitution and some progressives who adopt aspects of the Republican one. Many people flit between conceptions, depending on which happens to conform to the results they like that day. I contend that what divides those who adhere to a democratic constitution and those that favor a Republican constitution are two fundamentally inconsistent visions of we the people that lead to two radically different conceptions of popular sovereignty. Those who adhere to the democratic constitution hold a different conception of we the people, and popular sovereignty than those who adhere to a Republican constitution. So before describing the specific differences between the Democratic and Republican constitutions, let me begin by explaining the role that popular sovereignty plays in our thinking about the Constitution. The concept of popular sovereignty was first developed in the United States at the time of the founding. Back then, it was a first principle of political theory that sovereignty, or the right to rule, must reside somewhere in any polity. While the ultimate sovereign was thought to be God, who ruled the world, on earth, monarchs claimed to be the sovereign rulers of their own people, ruling by delegation from God, or what was called divine right. When the Americans had their revolution and rejected the rule of the English king, political theory of the day required them to say, well, just who is the sovereign in your new polity? The answer they gave was that the people themselves were the ultimate sovereign. But this raised at least as many questions as it answered. If sovereignty was the answer to the question of who has the right to rule, in what sense do the people rule? This seems like a contradiction. We need government to rule the people, and yet the people themselves are supposed to be the ultimate ruler. Now, what I'm calling the Democratic Constitution is one way to address the problem of how the sovereign people can be said to rule. When we the people is viewed collectively or as a body, popular sovereignty means rule by the people as a body, and rule by the people means rule according to the will or desires of the people as a group. Now, of course, it makes perfect sense to talk about the will or desire of a sovereign monarch. But in what sense does a body of individual persons have a collective will or desire? What is the will or desire of the group in this room at this moment, for example? Now, no one who makes assertions about the will of the people ever claims that there must be or ever is a unanimous consent of everyone to some particular desire. In practice, the collective will of the people must rest on the desires of a majority or a supermajority of the people. It does not, because it cannot, rest on the desires of everyone. Therefore, in operation, a conception of popular sovereignty based on rule according to the will of we the people means rule according to the will of a majority of the people. So the Democratic Constitution starts with a collective vision of popular sovereignty based on the will of we the people as a group, and the will of we the people can then only be that of the majority or greater number. According to this conception, then, a legitimate constitution is a democratic constitution that sets up institutional mechanisms by which the desires of the majority of the people can be expressed. Perhaps in local affairs, everyone can get together in a town hall meeting and express their views and vote, just as citizens of Athens once voted in the Forum. But in any larger polity, we must rely on elected representatives of the people who are supposed to represent the views of a majority of their constituents in legislative bodies. This is known as representative democracy. Legislators, under this view, are thought to speak for the people and express the people's will. If a well-constructed democratic constitution based on a collective conception of popular sovereignty is one that allows the views of a majority to prevail, then a number of important implications follow from this. First and foremost, any principle or practice that gets in the way of the will of the majority or majority rule is presumptively illegitimate and requires special justification. Under the Democratic Constitution, the only individual rights that are legally enforceable are a product of majoritarian will, whether the will of majorities in the legislature who create legal rights or the will of majorities who ratified the Constitution who create constitutional rights. It all comes from the majority. So under a democratic constitution, first comes government, and then come rights. First, one needs to establish a polity with a legislature that represents the will of the people, and this legislature will then decide which rights get legal protection and which do not. The democratic constitution is also a living constitution, whose meaning evolves to align with contemporary popular desires, so that today's majority is not bound by what's called the dead hand of the past. After all, by what right does the will or desires of yesterday's majority override the will of a majority today, if majorities are supposed to be ruling? Under the democratic constitution, Unelected judges who are not accountable to the majority represent what Alexander Bickel called the counter-majoritarian difficulty. Judges are not selected to represent the desires of anyone. They are appointed, not elected, and in the federal system they serve for life. To the extent they invalidate popularly enacted laws, these unelected and unaccountable judges are thwarting the will of the people as manifested by their elected representatives. Under the Democratic Constitution, judges are told they should exercise their power of judicial review with restraint. They should defer to the will of popularly elected branches by adopting a presumption of constitutionality that simply presumes, in some cases irrebuttably, that properly elected legislators have acted properly when they restrict the liberties of the people. For the people are only restricting themselves, we are told, and how they wish to govern themselves is for their democratically selected representatives to decide. Now, today the belief in the Democratic Constitution is so pervasive amongst both progressives and conservatives, amongst Democrats and Republicans, indeed, I think amongst many people in this room, that you might be just sitting at your table wondering, well, just what other view of the Constitution could there be? Perhaps the most important point of this talk today and of my book is just to identify and describe this other view, what I'm calling the Republican Constitution, so that you can recognize it as a distinct vision of the Constitution. So, Republican Constitution. What separates the Republican Constitution from the Democratic Constitution is its conception of popular sovereignty. Where the Democratic Constitution views sovereignty as residing in we the people collectively or as a group, the Republican Constitution views sovereignty as residing in we the people as individuals. A Republican Constitution views the natural and inalienable rights of the individuals who comprise we the people as preceding the formation of governments, so that first come rights and then comes government. Indeed, as the Declaration of Independence tells us, it is, quote, to secure these rights that governments are instituted among men, to secure these pre-existing rights. This individualist conception of popular sovereignty was most strikingly presented in the first great constitutional case decided by the Supreme Court in 1793, just 4 years after the Constitution was adopted. The case was Chisholm versus Georgia, and it involved a lawsuit brought against the state of Georgia by a citizen of South Carolina. The suit was for breach of contract to pay for goods that had been supplied to Georgia during the Revolutionary War. Now, Article 3, Section 2 of the Constitution specifies that, quote, the judicial power of the United States shall extend to controversies between a state and citizens of another state. That's what the Constitution says, between a state and citizens of another state, which certainly seems to cover a suit brought by a citizen of South Carolina against the state of Georgia. The state of Georgia, however, asserted that it had sovereign immunity from such a suit and refused even to appear in the Supreme Court to defend itself. In Chisholm, the Supreme Court, by a vote of 4-1, rejected Georgia's assertion of sovereign immunity. The majority concluded instead that members of the public could sue state governments because sovereignty rests with the people rather than with the states. The justices in Chisholm affirmed that, in America, the states are not kings and their legislatures are not the supreme successor to the crown. Justice James Wilson, who had been among the most influential of delegates to the Constitutional Convention, began his opinion by stressing that the Constitution nowhere uses the term sovereignty. He said, quote, to the Constitution of the United States, the term sovereign is totally unknown. He said there was one place in the Constitution, quote, where it could have been used with propriety, referring to the preamble, but, quote, even in that place, it would not perhaps have comported with the delicacy of those who ordained and established that Constitution. They might have announced themselves sovereign people of the United States, but serenely conscious of the fact they avoided the ostentatious declaration, unquote. Wilson contended that if the term sovereign is to be used at all, it should refer to the individual person. Quote, laws derived from the pure source of equality and justice must be founded on the consent of those whose obedience they require. The sovereign, when traced to this source, must be found in the man, meaning the individual person. In other words, obedience must rest on the consent of the individual person who is being asked to obey the law. Wilson believed that the only reason, quote, a free man is bound by human laws is that he binds himself, unquote. For Wilson, states were nothing more than an aggregate of free individuals. He said, quote, if one free man, an original sovereign, may bind himself to the jurisdiction of the court, why may not an aggregate of free men, a collection of original sovereigns, do likewise? If the dignity of each singly is undiminished by having to appear in court, the dignity of all jointly must be unimpaired by having to appear in court. Now, Justice Wilson was not alone in locating sovereignty in the individual person. In his opinion in Chisholm, Chief Justice John Jay, our first Chief Justice, who with Madison and Hamilton had authored some of the earliest Federalist Papers, referred tellingly to, quote, the joint and equal sovereigns of this country, unquote. Jay affirmed the great and glorious principle, I'm quoting now, the great and glorious principle that the people are the sovereign of this country, and consequently that fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined, unquote. In his discussion, Jay refers to what he called that popular sovereignty in which every citizen partakes, clearly connecting his conception of individual sovereignty with that of popular sovereignty. Justice Wilson and Jay's individualist conception of popular sovereignty present the radical yet fundamental idea that if anyone is sovereign, it is we the people as individuals, in the citizenry as a whole, rather than in a majority of the electorate. Now, what are the implications for adopting an individual rather than a collective conception of popular sovereignty? I contend that an individual conception of popular sovereignty yields a republican rather than a democratic constitution. The theory of what I'm calling our Republican Constitution was quite clearly expressed in the Declaration of Independence, which stated that every person has a natural and inalienable right to life, liberty, and the pursuit of happiness. Notice those were all individual rights. And that it is to secure these rights that governments are instituted among men. So the proper measure of any government is how well it protects these rights. So under a Republican Constitution, first come rights, and then comes government. Under the Republican Constitution, because the people consists of each and every person, the power to govern must be delegated to some subset of the people. This small subset of the people who are empowered to govern are not to be confused with the people themselves, but are considered to be mere servants of the people. Some of them work, Georgetown Law is within 2 or 3 blocks of the Capitol. I work within a few blocks of the 535 people there. They're just 535 individual people, a subset of the people. They are not the people themselves. The people are the principals or masters, and those in government merely their agents. As agents, they are to govern on behalf of the people and subject to its control. Elected legislators are not the voice of the people. Elections empower the people to check the legislature. To ensure these subjects, these servants, remain within what the Declaration called their just powers, deriving their just powers, that's what the Declaration says. In addition to elections, under a Republican Constitution, this lawmaking power must itself be limited by law. The Republican Constitution, then, is the law that provides the law that governs those who govern us. The Constitution is not the law that governs us. The Constitution is the law that governs those who govern us. And it's put in writing so that it can be enforced against the servants of the people. There it is. It's in writing. This is the Cato Constitution, by the way. What I like about the Cato Constitution is it inserts the word liberty randomly throughout the document. You just read anything right, and also liberty will just pop up. No, actually, it's the verbatim real Constitution. They wouldn't really change it on us. The Republican Constitution provides the law that governs those who govern us, and it's put in writing so that it can be enforced against the servants of the people, each of whom must swear a solemn oath to obey this Constitution, not the living one, not the Supreme Court's Constitution. The oath is to this Constitution. These servants or agents must swear an oath to this Constitution, the written one. Those who swear such an oath can no more change the law that governs them, that's in this book, than we can change the speed limits that are imposed on us without going through the appropriate amendment or change process. In short, under the Republican Constitution, the meaning of the written Constitution must remain the same until it's properly changed, which is another way of saying that the written Constitution should be interpreted according to its original meaning until it's properly amended. Under the Republican Constitution, judges too are servants of the people who have a duty to adhere to the law of the Constitution above any statute enacted by Congress or by the states. Judges are given lifetime tenure precisely so that they may hold legislatures within the proper scope of their just powers, and by so doing, protect the individual rights retained by the people and the privileges or immunities of citizens from being denied, disparaged, or abridged by their servants in the legislature. So in my book, I explain how we have a Republican rather than a Democratic Constitution. To address the problems caused by democratic state governments under the Articles of Confederation, a new and more Republican Constitution was devised in Philadelphia to provide for a more perfect union. To better secure the natural rights of the sovereign people, states were barred from impairing the obligations of contract or interfering with interstate commerce or commerce with foreign nations. These and other powers were placed in the hands of a new form of national government. The powers of the national government were then divided into three separate and co-equal branches, each of which was to check and balance the others. Lawmaking power was to be separate from its enforcement, and an independent judiciary was empowered to ensure that all three branches played by the rules laid down in the Republican Constitution. A more democratic House was to be checked by an undemocratic Senate appointed by the states. And the lawmaking power of Congress was then limited to those powers herein granted, which is in the first sentence of Article 1 that defines the legislative powers. Congress has all powers herein granted, and to which, in the Constitution, to which all then must take an oath to uphold. Our Republican Constitution was then put in writing to assure that it not be forgotten. Now, unfortunately, even the new and improved Republican Constitution was incomplete. Southern states continued to maintain their tyrannical and unjust rule by a majority over their slaves, whose pre-existing rights to life, liberty, and the pursuit of happiness were altogether denied. Eventually, a new Republican Party with an expressly anti-slavery agenda arose, supplanting the Whigs. In just 6 years, it captured the presidency and control of Congress, which induced the southern slave states to secede from the Union, taking those they held in bondage with them. After the Civil War emancipated the slaves by force of arms, the Republicans in the 38th Congress drafted and secured ratification of the 13th Amendment to forever abolish slavery as an institution and give Congress the enumerated power to enforce that abolition. But winning the war and amending the Constitution turned out not to be enough. Southern racists resisted the new constitutional order, engaging in a brutal campaign of public and private terrorism. So, the Republicans proposed two new amendments that would greatly improve our Republican Constitution. The 14th Amendment would protect the privileges and immunities of U.S. citizens from being abridged by their own states. Then, when the incentives of the 14th Amendment for black suffrage proved inadequate, the Republicans drafted and secured the ratification of the 15th Amendment to guarantee the rights of blacks to vote, though it would take another 50 years for women to be guaranteed the right to vote in the Constitution. Sadly, all these efforts to complete the Republican Constitution were stymied by the Supreme Court. In case after case, the court gutted one provision after the other, effectively nullifying key provisions of the written Constitution itself that stood in the way of the more democratic government that was being advocated by Southern racists in the South bent on continuing their subordination of the black minority. For example, in Plessy versus Ferguson, the court completely deferred to the southern states using their police powers to segregate races supposedly to ensure the public order. In the North, progressives like Theodore Roosevelt and Woodrow Wilson were urging judicial restraint from invalidating progressive state legislation there. From that day until this, one provision of our Republican Constitution after the other has been interpreted out of existence in the name of making what my friend Sandy Levinson has called our undemocratic Constitution more democratic. But it's no coincidence that the textual provisions of the Constitution that recognize and protect the individual nature of popular sovereignty have had to be ignored to make our Constitution more democratic. Take the Ninth Amendment, which affirms that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. We know these rights are retained by the people as individuals because the Ninth Amendment was added to prevent construing the other individual rights that were enumerated in the Constitution as the only rights the people have. The 10th Amendment affirms that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So the Constitution here acknowledges that the people may retain powers as well as rights, and it expressly distinguishes the people from the states, the way the court did in Chisholm. And the 14th Amendment says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, which altered our system of federalism to create a power in Congress and the federal courts to protect the privileges or immunities of citizens from being abridged by their own state legislatures. But what are these individual rights that are retained by the people? The idea of individual popular sovereignty helps us better to understand just what rights and powers, privileges and immunities are retained by the people. Because under a Republican Constitution, the rights and powers retained by the people resemble those enjoyed by sovereign monarchs. Think about it. Just as sovereign monarchs claim jurisdiction over their territories, sovereign individual citizens have jurisdiction over their private property. Just as one monarch may not interfere within the territorial jurisdiction of another monarch, no citizen may interfere with the private person and property of another. Just as monarchs may consensually alter their legal relations with each other monarchs by entering into treaties, so too may individual citizens alter their legal relations with their fellow citizens and joint sovereigns by entering into contracts with each other. Now, of course, the Republican Constitution was established in part so that these liberties of the individual can be regulated by law. But the proper purposes of such regulation must be limited to the equal protection of the rights of each and every person. A law that does not have this as its purpose is beyond the just powers of a Republican legislature to enact. In short, when the liberty of a fellow citizen and joint sovereign is restricted, judges, as agents of the people, have a judicial duty to critically assess whether the legislature has inappropriately exceeded its just powers. Now, this does not mean that judges should be speculating about the natural rights of man and then enforcing these judicially discovered rights against the other branches. This is not what they have been trained as lawyers to do. Instead of singling out special rights or special groups for special protection, judges should be ensuring that laws restricting the life, liberty, or property of any person are not irrational or arbitrary. Irrational or arbitrary. A measure is irrational if the means it adopts poorly fit the supposed end for which it was passed. A measure is arbitrary if the liberties of some are being restricted in the ways that the liberties of other similarly situated people are not being restricted. The aim of such an inquiry is to ascertain whether a particular restriction on liberty was enacted in good faith or was instead enacted to serve a purpose that is outside the legitimate police power of a Republican legislature. Such illicit motives for legislation include the desire to benefit some persons or firms at the expense of others, or the desire to stigmatize or make it more costly to exercise a liberty of which the legislature or majority disapproves. In other words, courts should be trying to smoke out pretextual legislation that only purports to serve, for example, a health and safety rationale, but is really enacted for another improper objective that we, the people, cannot be presumed to have authorized a Republican legislature to pursue at the expense of our liberty. Today, we live in a world in which most people invoke both the Republican and Democratic constitutions. Sometimes they favor the will of the people, and other times they urge the protection of individual rights. They opportunistically assert the will of the people when it favors their policy positions, and the rights of individuals to be free of what they call the tyranny of the majority when it does not. Only by recognizing the difference between the Democratic Constitution and the Republican Constitution can we ever hope to recapture the benefit of realizing that first come the rights of we the people as individuals, and only then comes government as our servant. The benefit of realizing that the will of the majority is not the solution to the problem of constitutional legitimacy, but it's the problem a Republican form of government is needed to solve. For only a Republican Constitution, like ours, if followed, can secure the sovereignty of the people, the sovereignty of we the people, each and every one of us. Thank you. I thought I was free to leave, but it turns out there is time for questions. 3 questions, I'm told. 3 questions. So, I see a hand right there. I can't see you, but I can see your hand. This is a Georgetown law graduate. That's what he's trying to make a reference to here. We met earlier. Right. Well, look, the constitutional framers designed the Constitution as a structure like the structure of a ship. And they said, look, we've designed this structure so it won't sink, so come on board. And that there were many people who were afraid to come on board because they were afraid of, they didn't have as much confidence in the structure of the ship as the designers did. They insisted that lifeboats be put on the ship. The Bill of Rights are like lifeboats on the ship. They were never intended to be used because the structure was supposed to keep us afloat. But if the ship goes down, if the structure founders, if all those constraints of the Republican Constitution have been overridden, we're stuck in the lifeboats, and we should be grateful we have them. So I think we're better off for having the lifeboats to keep us afloat, even though we would be even better off if we could restore the structure of the Constitution and we wouldn't need to rely on the lifeboats so much. So in that sense, I both agree with those founders who thought the lifeboats, the rights would be dangerous, which is why the Ninth Amendment was added to negate that danger. But I also agree with the anti-federalists who thought, you know, if the structure doesn't work, we need the lifeboats. And I'm saying that, look, if we didn't have the First Amendment and the Second Amendment, we'd be in a lot worse fix than we are today. That wasn't meant to be an applause line, but applaud for the First or Second Amendment is, yes. Well, this is one of many things that the question is if the people are sovereign and the governments are servants, how and when should the government ever be able to claim sovereign immunity? And Chisholm versus Georgia was about a claim of sovereign immunity, and the court rejected that 4-1. And then the states objected, and they passed the 11th Amendment, which it didn't actually endorse sovereign immunity, but it allowed them to avoid being sued in federal court. So the Constitution was amended by the 11th Amendment to prevent states from being sued in federal court. The courts have done a lot of things that are wrong. That's just one of many things that are wrong. Our legislatures and our servants, and even prosecutors like myself, when I used to be a prosecutor, should not be immune from our own misconduct just because we are government officials, if we're servants of the people. Now, you have to remember, though, that we live in a situation in which people can be sued for almost everything. So this assumes that you can only be sued within the narrow boundaries of having really violated someone's rights. And we know that our legal system have moved way beyond that. So we have to realize that one of the reasons why state governments are asserting sovereign immunity from lawsuits is because if they don't, they're going to be bankrupt by plaintiffs' attorneys. And who's going to pony up the bill? Not the people in government, but the taxpayers are. So in a system in which litigation is wide open, sovereign immunity, unfortunately, does play some role in protecting the public treasury that's supplied by the taxpayers from being raided by tort lawyers of various kinds, or by lawyers of, by clients and lawyers and their lawyers. And I don't want to get down on lawyers now because I'm actually a big fan of lawyers, and if you're ever wrongfully accused of something, the only thing that stands between you and a wrongful conviction is going to be your lawyer, and you better hope you have one, and you better hope that he or she is a good one. One more, the last one. Yes.
If the Articles of Confederation were such a failure, what led, and because the state governments wanted to do what they were doing?
That's
If
helpful.
the Articles,
Yes.
if the Articles of Confederation were, if the Articles
The microphone's a failure, too.
If the Articles of Confederation were a failure because the states rejected the Republican approach, how did they come together to create the Republican approach?
Right. Well, basically the point I'm saying is that the concept of republicanism changed. They started off with, they always had first come rights and then comes government, because that's what the Declaration says in 1776. But then how do you protect these rights? They thought the people wouldn't screw themselves. And then they found that when they were given the power to rule by a majority rule, the people did screw themselves. So in a sense, they sent new delegates. James Madison worked behind the scenes along with other people to create, in some sense, a new revolution in which they would send delegates to another convention in Philadelphia, and then that convention then had to recommend something that the states would have to either buy into or they wouldn't be bound. No state was bound by the Constitution who didn't want to be. The Constitution would go into effect when 9 states ratified it, but any state that didn't ratify it didn't have to be bound by it. In fact, for 2 years, 2 states, Rhode Island and North Carolina, Rhode Island and North Carolina were not in the Union. And one of the reasons why Madison proposed the amendments be acted to the Constitution was to induce those people to join because they didn't want to get on the ship without the lifeboats. So they thought this would make them more likely to join if we could put the Bill of Rights in there. And so that's how it happened. It happened through political action. And that's how it's going to have to I'll end on this note, that's how it's going to have to happen today. It's not going to happen by judges. It's not going to happen from clever lawyers making up novel arguments and going to court and letting the Supreme Court save us. I can tell you, as one of the lawyers in the Obamacare challenge, who was there from before the law was passed, that we didn't save the country from Obamacare then, and we're not likely to use the courts to save the country from other Obamacares in the future. What it requires is political activity. That's what it required in order to get the Constitution we have. It's going to be required to get it back. What requires is a citizen movement that's committed to this. And fortunately, for the first time in my life, we have such a citizen movement. Sometimes it's called the Tea Party. Sometimes it's called other things like that. But there's a movement for what's called constitutional conservatism, which is a movement back to the text of the Constitution. If we can get a president who's committed to this, who appoints judges who are also committed to this, and they will then be confirmed by a Senate. Then we can begin to move. That's how this Constitution is written, to move us back to restoring this Constitution, which unfortunately is lost, but which has never been repealed, and which therefore can be brought back. Thank you.